In this video, we're going to discuss whether your beneficiaries should have a Spendthrift Trust. Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. So, what is a Spendthrift Trust? A Spendthrift Trust is a setup that does not allow the beneficiaries direct access to the funds. They have to go through the trustee and be approved by the trustee. And they are also not able to promise the trust funds to creditors. So at any point, the trustee can say, no, we are not making a distribution, which also allows the trust to say no to paying for claims of creditors. If the trustee is required to say yes, then the trustee is also required to pay creditor claims. So that is what a Spendthrift Trust is. Why might you want this? Any number of reasons. Anything from creditors, as we've discussed, to bad relationships, divorces. As soon as we get these funds and potentially commingle them, because, of course, inheritances are not joint property, but people often put them in joint bank accounts, commingle them. So we don't want these things to be, part of a divorce or accessed by someone that we don't think is good. Maybe drugs, alcohol, general addiction issues, gambling, even just youth. You're too young to handle the money responsibly. So these are all great reasons to have a spendthrift clause in your trust. In fact, I would argue that almost universally, if you are putting assets in trust, you want that spendthrift clause. There is no good reason for creditors to be able to access this money. The real question is when, if at all, does the money come out of the trust so that the beneficiary has personal access to it? And that can be at a certain age. So we can say, some of the money is coming out at 25, some of it's coming out at 30, some of it's coming out at 35, or, maybe all of it's coming out at 30. Or we can say it stays in trust forever. So a trustee is always overseeing making the distributions. It's however you want to plan that. But as long as the money is in trust, managed by a trustee, a creditor should not be able to access it. So we do want spendthrift provisions. That being said, if you set your child up as the trustee of their own trust, creditors are very likely going to be able to access it. So that is something to consider, even if we have a clause that says, all of these spendthrift things. If you are trustee of your own trust, here in Georgia, creditors are going to be able to access. We are, fortunately or unfortunately, very creditor friendly in this state. As long as someone else is trustee and has the power to say no, then we have some protection. If this is something that you are thinking about, wondering about, please come talk to me, give me a call. I would love to hear from you. And thank you for watching, and please like and subscribe.